Stand as the jury comes in.
Wait, you know what? No, I've been in front of jurors. Oh.
You may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session and cause number 24 CCCR 1096. Case is styled the state of Texas versus Kit Don. Mr. Don is present in court with his attorney. Attorney Zuniga. State is present with Assistant Criminal District Attorney Denise Williams and Attorney Farrah Nixon. State, are you ready?
State's ready.
Defense, are you ready?
That's ready, Your Honor.
And let the record also reflect that the jury is now present and seated in the courtroom. Mr. Williams, you may proceed.
Through the testimony yesterday, Your Honor, and as we stand now here today, the state will rest this case in chief.
Okay. At this time, the state has rested its case. Mr. Zanik.
That's rest and close, Judge.
Okay.
And
So
we would just have a motion outside the presence of the jury present.
okay. Ladies and gentlemen of the jury, hold on a minute. Jefferson County Court, law number 2 is back in session. The court is in session in cause number 25 CCCR 1350. Case is filed in the state of Texas versus Nathan Aaron Bonnier. Mr. Bonnier, is that your full name?
Yes, sir.
Mr. Bonnier, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Bonnier, you may put your hand down. How are you doing, Mr. Bonnier?
Pretty good. How you doing, Judge?
I'm doing fine, thanks for asking, Mr. Bonner. You're represented in your case by your attorney, Attorney Todd LeBlanc, who is appearing via Zoom. Mr. LeBlanc, how are you doing?
Good, Judge. Thanks for asking.
Welcome. Mr. LeBlanc, do you waive a record in Mr. Vonnier's case?
We do, Your Honor.
Mr. Vonnier, I have before me a document that is titled Joint Request for Plea and/or Sentencing by Video Conference under Texas Code of Criminal Procedure, Article 27.18. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
I also have another document on my computer that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Nathan Aaron Vonnier, on or about March 26th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failed to identify a fugitive with intent to give false information. Mr. Vonnier, you understand what you've been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Sir.
Mr. Vonnier, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document?
Sir.
And on page 2 of this document, there's a set of initials on the line next to boxes checked null or contingent. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Vonnier, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Vonnier, are you a citizen of the United States?
Yes, sir.
State, would you like to offer State's Exhibit Number 1 in evidence?
So tendered, Your Honor.
Mr.
No objection, Your Honor.
Okay, no objections. State's Exhibit Number 1 will be admitted. Mr. LeBlanc, you advised in counsel. Mr. Vonnier, is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
And Mr. Vonnier, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Vonnier, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
We got 12 days in the Jefferson County Jail, time served, time actually served. Is that correct, Mr. LeBlanc?
Yes, that's my understanding.
Okay. Mr. Vonnier, the state is offering that you serve 12 days in Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail. Because you've already served 12 days in Jefferson County Jail, therefore you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Vonnier, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Vonnier, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Reiner, you're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go. And you have a blessed day and have a safe trip home.
Yes, sir. Thank you.
You're welcome. To Janica Rashawn Simpson.
Yeah, we're ready. Come on. No, I'm sorry.
Okay, she's gonna go get her.
I'm going to grab it. You're welcome. Oh.
10 days. Ms. Simpson, your full name is Tajanica Rashawn Simpson.
Yes, sir.
Ms. Simpson, would please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Simpson, you may put your hand down. How are you doing, Ms. Simpson?
I'm fine, and yourself?
I'm doing fine, thanks for asking. Ms. Simpson, you're representing the case by your attorney Langston Adams. Mr. Adams, how are you doing?
Doing well.
And Mr. Adams, do you waive a record in Ms. Simpson's case?
Yes, sir.
Ms. Simpson, I have before me on my computer a document that is titled Information. This information was filed by Jefferson County District Attorney's Office. In this information, it alleges that you, well, in cause number 25 CCCR 2934, this information alleges that you, Janica Rashawn Simpson, on or about October 20th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, or transportation. Ms. Simpson, do you understand what you've been charged with?
Yeah.
And to this charge, how do you plead? Guilty, not guilty, no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Freely.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Now, Ms. Simpson, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on a line next to a box that's checked. I will continue. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And on the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box is checked, states that you're waiving your right to the appeal, which means you're giving up your right to the appeal. Do you understand that statement?
Yes.
You know, the discovery certification.
Yes, I turned them in on both of them.
Okay. And I also have a document on paper that's titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Ms.
Correct.
Simpson, before you sign and initial all of these documents that I'm showing you, did your attorney go over these documents with you?
Yes.
Did you understand everything that he went over?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Ms. Simpson, are you a citizen of the United States?
Yes, sir.
The state will offer State's Exhibit number 1, Your
Any
Honor.
objections?
No.
No objection. States Exhibit number 1 will be admitted. Mr. Adams, you advised that counsel, Ms. Simpson, is there any evidence that she is currently mentally incompetent to stand trial?
None.
And Ms. Simpson, your attorney, Mr. Adams has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir. Yes.
Ms. Simpson, I will accept your no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your
And
Honor.
what is that agreement?
11 days?
It's 10
Was
over
it
here.
10? Okay, 10 days, time served, time actually served. And retired court costs, Judge.
Okay. Ms. Simpson, the state is offering that you serve 10 days in Jefferson County Jail, but you will not be required to serve any more time in the Jefferson County Jail on this case because you've already served 10 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you already served. The court costs in this case will be taxed and retired. That simply means that you will not have to pay the court costs because the time that you paid and spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Simpson, do you understand the state's
Yes.
offer? Do you think that the state's offering your case is fair and just?
Yes.
Do you accept the state's offer? Okay, Ms. Simpson, I'll follow the plea bargaining agreement that you have entered into with the state. Now, I don't have the paperwork on the other,
Judge.
no, I don't have the stuff on the tablet.
I did. No, you talking about. on-
Yeah, it's unagreed, but you still have to
I
fill
did,
out.
I did both cases on tablet. I sent them both. Yeah, she
You-
signed both. I'm positive. I'm 100% sure.
Yeah, say that.
Okay, he may have to send them to, yeah. The DA, okay, the head send it.
I did. I just wrote on top of it.
Jefferson County Court, Law number 2 is back in session. Court is in session. And cause number 26 CCCR 0369. The case is styled the state of Texas versus Tajanica Rashawn Simpson. Ms. Simpson, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Tajanica Rashawn Simpson, on or about November 18th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Ms. Simpson, do you understand what you've been charged with?
Okay.
To this charge, how do you plead? Guilty, not guilty, no contest?
Okay.
Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Right.
Ms. Simpson, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. And do you recognize this document?
Yes, I do.
This document is also labeled as State's Exhibit number 1. On page 2 of this document, there's a set of initials on the line next to a box that's checked no contingent, which means no contest as you place your initials on this document. On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature? And on the next document, the title trial court certification of the defendant's right of appeal. Do you recognize this document?
Yes, I do.
And is this your signature on the line that's titled defendant?
Correct.
At the top of this document, there's one box checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
On the next document is titled Discovery Certification. Do you recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
Yes.
Before you sign and initial all these documents that I'm showing you, did your attorney go over these documents with you?
yes, I do.
And did you understand everything that he went over?
Yes, I do.
And is everything in these documents true and correct to the best of your knowledge? State, you like to offer States 1?
So tendered, Your Honor.
Any objections?
No, sir.
No objections. States Exhibit number 1 will be admitted. The court will accept Ms. Simpson's plea of no contest. The court will find that she is mentally competent to stand trial. The court will also find that her plea and waivers were freely and voluntarily given. The state will also find, well, the court will also find that there is sufficient evidence to find her guilty beyond a reasonable doubt. Now, state, this is an unagreed plea bargain, is that correct?
That's correct, Judge.
Okay, what is the state's minute?
May the state humbly request, although while it's unagreed, that a pre-sentence report be done.
Yeah, well, if you're gonna do a pre-sentence report, she's going to be, you gotta go to jail.
No, I don't.
Do a pre-sentence?
Yeah.
Yeah, because the pre-sentence is gonna take 30 days. I thought y'all wanted to
Yeah,
dispose of it
okay.
today.
Mhm.
Okay, now you can, now.
I would like to make an argument in aggravation, Judge, but just being candid, with this case, the matter just came before the state. We reached out to contact again, and all I can share with the court was the defendant's prior background, and I will do that, which would only be like the convictions. And I will point out that while out on bail, in another case though, she committed this assault. Let me take a look at her criminal history.
Yeah, but I mean, before we even started this plea,
Mhm.
it was understood by all parties involved that the case wanted to be resolved today, and now you're coming and asking for a pre-sentence investigation report that's
He
gonna
wanted
take
to
30
resolve-
days.
Judge, initially, I was unaware of like the other case until I was informed of the case. That's why I requested of the court. So just so we're clear, Judge, so we could try to contact again the victim. He wanted to do it, that's why he's doing like an open plea to the court.
Yeah, but as I mentioned to you earlier, the law requires that the state contact victims in these type cases.
Correct. Well, the
Okay?
state tried to
And I
make contact.
tell you that the
Sure.
court is gonna comply with the law,
Okay,
which means that the court will allow you to contact the victim. The court is not, it's not gonna go forward with a plea without the contact being made.
it's the state's position, Judge. We had, at this juncture, we did reasonable contact to reach out again to the victim within the case. Judge.
Okay.
Oftentimes, and even in some cases, all we can do is do reasonable efforts to contact. If that happened to fail, then we still think the state complies
Well-
with the statute, Judge. I'm not
Well-
trying to defend, I'm just saying, oftentimes,
Well-
we may not be able to get to people, they may not return our calls.
Yeah, but you have to exercise due diligence. Now, let me do this. Hold on a minute. Okay,
He's at the doctor's anyway.
okay, so, let's see, so, Mr. Williams, the state has made an attempt to contact the victim in this case, is that correct?
That's correct, Your Honor.
And you relayed to the court, while we were off air, that, the victim, the numbers that you were given, those numbers was disconnected,
That is correct, Your Honor.
and you had an investigator to try to, make contact as well,
That is correct, Your Honor.
and the investigator has been unable to make contact.
That is correct, Your Honor.
Okay. Okay,
Just
now,
also, the record is clear, Judge. The state received notice that this matter was on for today. Able counsel for defense wanted to enter an unagreed plea. So between a time of 12 noon and 3:21 as it stand now, the state did make 3 attempts to contact the victim. With that, the state has nothing further, Judge.
okay,
We ready?
okay, so, Mr. Adams, you'd like to make your argument and punishment?
Yes, and I just got one super fast punishment with.
Oh, Judge,
That's okay.
I'm sorry, Judge.
And
Judge, we've been having
I'm gonna, because I know this is too much.
no, what's much.
uh, 10 days credit for time served, and the state was willing to do that. For this case, I'm asking, since it is, as Mr. Williams pointed out, she got her offense while the pending case was going. I'm asking for 30 days in jail, suspend that sentence, and put her on probation for 180 days with $100 fine and 40 hours of community service. In the alternative.
now, what was that?
Hmm?
What was your, you said,
Oh, what I was saying.
you
is
said,
that
you said 30
30 days
over,
in jail.
over 6 months?
and
over-
over 180 days. And
Okay.
then 40 hours of community service and $100 fine. And in the alternative, Judge, I was gonna ask for you to go with 1 year deferred adjudication, $500 fine, 60 hours of community service. And the reason that I was asking for that is that my client specifically is the sole provider of her mom transportation. The mom has cancer. The mom can't drive at all with the cancer medicine that she's taking. She
Okay.
couldn't even leave and go anywhere to eat during lunch. And with my client, to my understanding from talking to her, and I think the state has available all of her criminal history, I'm not aware of any significant felony history at all. So without any significant felony criminal history, as well as her current circumstances, I don't believe she's gonna be a danger to herself or the society. I'm not
Okay,
aware of any kind of
okay,
drug
Okay,
problem.
what else we have?
So that's what I was asking for.
Okay, Mr. Williams?
Hold on, John. Respectfully, there is a felony conviction, and a felony conviction is for where it was a state jail, excuse me. Felony conviction from 2010 for abandoning and endangering a child. She received 2 years, that was on November 15th of 2010.
You said it was how much?
Uh,
The person received what?
It was a conviction, 2 years probation, in, I'm sorry, November 15th of 2010. She received 2 years probation where a conviction was entered for abandonment and endangering of a child, Judge, and that was in criminal number. criminal number 94944, and that was
94944.
here in the criminal district court. That is correct.
Okay. Any misdemeanors?
Was,
Mm-hmm. 94944. That was four. That's what you said, 94944. You know what?
I haven't.
They used to have the no You may be seated. Jefferson County Court Element 2 is back in session. The court is in session in cause number 24 CCCR 1096, case of style of state of Texas versus Kit Doan. Let the record reflect that Mr. Doan is present in court with his attorney, Mr. Zuniga. Let the record also reflect that the state is present with attorney Cornelius Williams and attorney Farrah Nixon. Let the record reflect that the jury is now present and seated in the courtroom. Prior to the jury exiting the courtroom, both the state and the defense have rested their cases. So, ladies and gentlemen of the jury, at this time, I will read to you the court's charge. The defendant, Kit Doan, stands charged by information with the offense of indecent assault, alleged to have been committed on or about the 22nd day of January of 2024 in Jefferson County, Texas. To this charge, the defendant has pled not guilty. A person commits an offense if, without the other person's consent and with the intent to arouse or gratify the sexual desire of any person, the person touches the anus, breast, or any part of the genitals of another person. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Consent means assent in fact, whether express or apparent. Now, if you find from the evidence beyond a reasonable doubt that on or about the 22nd day of January 2024, in Jefferson County, Texas, the defendant, Kit Doan, did then and there intentionally or knowingly and without the consent of Cecile Hope Short, hereinafter styled the complainant, and with the intent to arouse and gratify the sexual desire of any person, the defendant caused contact with the complainant's breast, buttocks, or vagina with his hands, then you will find the defendant guilty as charged in the information. Unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiffs upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror nor consider it yourself in arriving at a verdict. Our law provides that the defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations, or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation on this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, elect a full person, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of this charge is called the verdict page. The top portion states, "We, the jury, find the defendant not guilty as charged in the information of the offense of indecent assault." If that is your verdict, then your foreperson will sign on the top line. And it says, or at the bottom, "We, the jury, find the defendant guilty as charged in the information of the offense of indecent assault." If that is your verdict, then your foreperson will sign on the bottom line. Does everyone understand? Okay. So at this time, we will have closing arguments, and the state have Mr. Williams.
The state will waive its opening and reserve rebuttal, Judge.
Okay. And have you agreed on time? 10 minutes?
Sure.
Okay. Mr. Zanika, you may proceed.
If it pleases the court, Mr. Doan, state of Texas, and especially the ladies and gentlemen of the jury. First, I just want to start by saying thank you.
for your time. I know that today is seems like a very long day, and it has been a very long day. And if you knew what I went through to get here today, you probably appreciate exactly how long it's been, but thank you very much for your time and attention. I know we only had a couple of witnesses, but they were very important witnesses. I'm gonna start out by kind of just reiterating something that the judge said. The most important part of your job as a juror, as the judge pointed out, is not only to follow the law, but as the jury charge reads, strictly follow the law. Now, because the state files charges, because it's their burden, they have the last say. So after I sit down, they get to make their argument to you, and I don't get to rebut. And I don't know what type of impassioned, emotional argument Mr. Williams intends to make to you, but I don't intend to do that. I intend to ask you to strictly follow the law. And in that regard, I want to bring up the charge in this case and talk to you about the most important part of it: consent. 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 The reason why that's so important is because in my opening, I kind of focused on some things I thought the complaining witness was going to testify about. Things that I was actually concerned about that might have you guys thinking about whether or not there was an issue of consent. However, when she testified, and her testimony is the evidence, those are the facts you are to consider, she clarified all of that for us. And, you know, the thing about it is, when the judge gave you the definition of consent in the charge, and you'll get one of these, I just ask that you go back there and read the law, okay? The definition of consent is vitally important to this case, because consent means, according to this charge and the definition, assent in fact, whether expressed or apparent. But what that means is that somebody can expressly consent to something. Yes, you can touch me. Yes, you can kiss me. Yes, you can suggest I take my pants down and I'll take them down. Yes, we can cuddle. That's expressed. But the other part of that the law allows is apparent. What that means is that a person doesn't have to expressly say, yes, you have permission to do something. Consent can be apparent. And the reason why that's important is because that goes not just to specific words that are expressed, but specific actions. Now, one thing that we know through the complainant's own testimony is that she never said no. Well, you know what? That's not true. She did say no one time. Maybe you recall her testimony when she talked about disassociating and not knowing what was going on and kind of not being conscious and out of body experience and didn't really know what was going on. They were kissing, when they were touching, when he was touching her breasts, when she pulled her pants down. All of that time, she's going to have you believe that she's somehow disassociated. But if you recall her testimony, there was specific testimony in there where he asked whether or not they wanted to exchange oral pleasure. And she testified, I said no. Very consciously, I said no. How can you say no to one thing, but then just acquiesce and expect everyone to believe that he did not have permission or consent to move forward while they were together in that bed? I'm not going to sit here and call her a liar. You know, I I don't know why she said what she said. I don't know if she was shamed or embarrassed or what the situation was. But we do know that this entire scenario started out with consent. Consent to snuggle, consent to go to the room, consent to get on the bed. And then all of a sudden, she claims, well, I don't know, I was disassociated. And if you recall, when I asked her that specific question, if you disassociated, then how do you know what happened? And there was about a 15 to 20-second pause while she was trying to think of an answer. And notwithstanding that, she still has that one moment where she makes a definite response and says, no, I don't want to give you oral sex. And he says, what? Okay. You can't have it both ways, folks. You can't have it both ways. So the other thing is, if you recall from her testimony, not only did the defendant, not only was he the one to stop when these acts were going on, he was also the one that suggested he should leave. She didn't even ask him to leave. He stops during the acts. He stops when he's got his hand down her pants. He says, maybe I should leave. He makes the suggestion and then he leaves. He doesn't take advantage of it. If she was in a dissociative state and didn't know what was going on, he didn't take this further. He asked if there was a condom. She says no. That's where that part ends right there. He doesn't move forward with that. He went as far as she acquiesced through her actions, which is part of the definition, part of the law, part of consent. Now, I want to talk real quick about the charge again. I think I made it abundantly clear how important consent is, and you'll see it all throughout the charge. I do want to talk to you again about how each and every element is necessary to find him guilty. And again, one of those essential elements is consent. So you can't say, well, maybe all this other stuff happened, so we can find him guilty. No. The law says, the law I'm asking you to follow says that you have to find that it was non-consensual, whether expressly or whether there was some assent. And it was apparent that he had consent to do the thing that he did in touching, in kissing, in hugging, all of those things. Now, as I told you in the beginning as well, and it came to pass, my client did not take the stand, but fortunately, you were still able to hear from him through the state because they introduced his statement. So if you can recall through his statement, he mentioned that he was the one that wanted to stop. Complainant confirmed that. He's the one that said that he stopped, and he's the one that wanted to leave. Complainant confirmed that. The state talked about overlapping of stories. There's no overlapping of stories. He said, I touched her. She didn't say no. She said, I didn't say no. He said, I stopped. She said, he stopped. He said, I thought I should leave. She said, he suggested that he leaves. No overlapping. They were consistent. Now, I understand because I have a daughter of my own. I understand how it would be difficult to be sitting where you're sitting and think about, wow, this girl's life was affected by these events. But unfortunately, we're not in a situation where the charge talks about emotions or things being awkward or how somebody felt. The charge talks about the law that we have to, we're bound to apply in this case. The law that says that through her actions, she consented. This young man did not act without consent. And while you're thinking about how this may affect Miss Cecilia Short, think about how it could potentially affect Mr. Doan. A conviction like this on his record for the rest of his life at his young age. And this goes back to the very beginning. This was a situation between two college students. I mean, I don't know what to tell you. I don't know why she decided that it was not something that she wanted to, tell people later on. It was something that she wanted to.
Mrs. Zuniga, you have 1 minute.
Yes, Your Honor. But fortunately, we don't have to decide that. Because the law, this charge, doesn't say you have to decide what may or may not have been in her head. And furthermore, how he could have possibly known, based on the signals that she was given, how he could have possibly known what was in her head. So again, when you go back there, just ask you to please take your time, strictly follow the law. I think if you do that, and if you're able to put your emotions aside, you'll see that there's no other verdict you can come back with, except not guilty. And you'll find it on the verdict form, right there in the back, the top selection. Mr. Dunn is not guilty in this case. Thank you so much for your time. God bless and your deliberations.
Mr. Williams?
Thank you.
Why? He, being the defendant, knew, should have known about the consent in which he thought, which he knew that he had. Why then did she say, when she took the stand, because this was the evidence, she took the stand and she said, yes, she consented to the kiss. She consented to going back to her room. But when did that begin to change? You heard her from the stand. When he began to kiss her breasts, when he began to fondle her vagina with his hands, she said, she froze, it's the language that she used. She said that she was fearful, it's the language that she used. She said that she feared also of retaliation. Fear, frozen. Fear of retaliation. Well, she complied. I submit to you that each and every time when he feeling awkward, as he said, I will also point out to you all that from the statements, again, that he made, he's the one that said he's feeling awkward. If everything was so nice and copacetic, why would he state, once again, no less than 8 times? And it begins how lustful he is. He says it at the 7-minute mark on his statement. You see, Sergeant Martin was able to meet with him, to speak with him. You saw his demeanor when you watched his statement. Did he minimize? I submit to you that he did. But even in his minimalization, he made admissions. What were those admissions? It started to feel weird. Well, why did it start to feel weird? Why did it start to feel awkward? Because you knew she wasn't saying, yes, please continue. He could not imply, and she did not give implied consent, because each and every time he began to advance to his next maneuver, to his next assault upon her, to his next touching upon her, based upon the elements of the offense, she didn't consent because she froze. She didn't consent because she was fearful. She didn't consent because at this point, she stated that she was like disassociated. How does she remember? Her words also was it's like an out of body experience. She did not. She did not give him express permission. She did not expressly consent. She did not tacitly, or as we use in the law. You'll read it right here when the judge gives us, when the judge gives you views and stuff. Counsel asks you, follow the law, follow the law. I submit to you that one consent could always be withdrawn at any time. We spoke about that in Fatah. The second thing is consent means assent in fact, whether expressed or apparent. Well, he's lusty. He's thinking that he had with this apparent consent while someone again is fearful. While someone does not say anything. Now, counsel pointed out, oh, she said no when he asked her to perform oral sex on him. She said no. At this point, you also know that she said that after the breast, after she was assaulted by the breast, after she was assaulted by him touching her vagina, that out of body experience. At this point, he asked her, do you have a condom? She says no. Immediately followed, it wasn't 5, 10, 15, 20 minutes later, while he still lies there in the bed, you can deduce from the facts that was presented that he said, okay, no condom, let's have oral sex. And then once she said no, immediately what did he do? He took his hand and placed his hand upon his penis. This is all happening as she sits there, as she lies there, after he put her on top of him, after he got on top of her. You can't consent. They are, what, at least he's still a college student, she's not. They were college students at the time. The difference in age, one was almost 23, the other one had just turned, was 18 years old. Who was 18? You saw her demeanor on the stand. She's 20 now.
Your Honor, that's a
Who was-
misrepresentation of the facts. The defendant was 21.
Oh, okay, ladies and gentlemen of the jury. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. Okay, Mr. Williams, you may proceed.
Thank you, Ma'am. Scared. Road. Terrified. And the stage, in a state to where you are like that, alone, and alone. Cecilia Hope Sharp, she complied. She complied, but complying in that state of fear, that state of doing an out-of-body experience, complying based upon those factors is not consent. You have all the facts before you in this case. We ask that you apply your life experiences. I will conclude by saying this. you may infer, and the fact and the action that you carried on that day, is gone, and the subject of them. What am I sorry for? Why did I apologize? Because why did he apologize? Because of the arguments that was going on at the moment. He knew he had done something wrong. And what if there's something wrong that he had done? He had indecently assaulted a class. He indecently assaulted Cecilia Hope Sharp.
Okay. Okay, ladies and gentlemen of the jury, this has concluded the closing arguments by both counsels. You will retire to the jury room, and the bailiff will give you a charge. Let's see this here.
Everything's lane.
What is this, 120? Sure. 120, this is the natural flow of air.
Okay,
Put it out.
okay. Let the record reflect that the attorney for the state and the attorney for the defendant are present in the courtroom. I have received a message from the jury that it has reached a verdict. Will a bailiff, please bring the jury to the courtroom? Yeah. You may be seated. Let the record reflect that the jury is now present in the courtroom. Full person? Who is the full person? What's your name?
Beaver?
Okay, Mr. Beaver. Have you reached a verdict in this case?
Yes, sir.
Is the verdict unanimous? That is one that is agreed upon by all the jurors?
Yes, sir.
Ms. Bailey, can I see the verdict? Full person, is the verdict unanimous verdict of all members of the jury?
Yes, sir.
Okay. Mr. Don, would you please stand? We, the jury, find the defendant not guilty as charged in the information of the offense of indecent assault. Okay? You may be seated. Okay, lady and gentlemen of the jury, I'd like to thank you for your time and attention to this case. Your jury services are over, please. You could just place the badges on the counter. Okay. I'd like to thank you for your time and attention on behalf of the citizens of Jefferson County and behalf of the staff here in County Court at Law Number 2. We'd like to thank you for taking out your busy schedule to be here today. Without citizens like you, our court system cannot move in an efficient way because people like you take time out from your busy schedules to make sure that justice is done. Now, your jury service is concluded. Our district clerk's office is closed. If you need an excuse or anything, we can get you an excuse here. Everyone who has participated in this jury or in this trial will also be compensated for the time that they have spent. And we will send your names in to district clerk's office. Now, this concludes your service. The lawyers may want to talk to you about after you leave the courtroom. You do not have to talk to any of the lawyers if you do not want to. If you want to, you can, but you're not required to do so. Now, I always tell people this. Normally, I usually give everyone a handshake, but we still have COVID and we have this virus in our community, so I'm unable to do that. However, I would like to give each and every one of you an air handshake and thank you for taking time out from your busy schedule to be here. Each and every one of you have a blessed day. Our court bailiff is going to give you some letters. You're excused. Everyone, please stand. Yeah, yeah.
You said I could, excuse
Yes, yeah, just, y'all just have a seat right there because she's gonna do the judgment and the excuse. Okay, and this will conclude the trial of, Kit Don and cause number 24 CCCR 1096. Everyone, please have a blessed day.
Thank you.
You're welcome.
Having no further business before this honorable court, may the state be excused.
Yes, you may be excused.
That's the excuse number.
Yes, you want a copy of the judgment?
I'm sure that was the thing.
You know, them.
Okay,
Tell them how you do this. If they don't have them, you know, it should be.
It was all good. No doubt, justice.
I think,
Thank you guys again.
that's not right if it just says by the court.